titled Change in Landscape of Public Lands. Thank you for being here. Let's start first. I'd like to thank our sponsor of this panel, Pool Pact, and Mike Robioletti, if you'd like to give a brief few words.
Yeah, thank you, Colby. Yeah, I'm Mike Robioletti, Chief Operations Officer of Pool Pact. I wanted to thank Dagny and all the NACO staff and volunteers for organizing the 2020 Nevada NACO Annual Conference. And I want to also congratulate all the newly elected officials and congratulate any of the officials that may be termed out. You all do a great service to the state of Nevada, and we truly appreciate it. I know we're all doing the best we can with virtual meetings, but there is no substitute for actual meetings. So hopefully next year we'll be in the room together and be able to share dinners and everything else that we used to do at the NACO conference. For the Pool and Pact, it's an honor to serve all of the counties that we do. We have 14 of the 17 counties, and we provide insurance coverage and risk management services to over 124 local governments across the state of Nevada. So with all that being said, please enter our raffle. We have a lot of great raffle prizes. We also have a live stream presentation that's running throughout your entire conference. And we also have a live stream interaction where you can actually come and talk to us live during the conference. So we encourage anybody to come and visit us virtually. So thank you, stay safe, and the Pool Pact wish all of you a happy Thanksgiving. Thank you.
Thank you, Mike, and thank Pool Pact for their support of Nevada's counties. NACO would also like to thank the University of Nevada Cooperative Extension and the technical support they will be providing throughout this annual conference. Our economist Joe Lipnicki is leading that charge, and I'd like to say a few words of how this panel is going to proceed.
Hi, I'm Joe Lipnicki. Thank you very much for the kind introduction, Colby. As Colby said, I will be assisting with the technical facilitation of today's session. And due to the great amount of participation that we anticipate within this session, we have disabled the cameras, microphones, and chat for attendees. We encourage all attendees to participate by asking questions through Zoom's Q&A function. This will allow us to gather the questions to be answered at the appropriate time during the session. And as a reminder to our moderator and our guest speakers, I may hop in from time to time if there are any technical hiccups or other items that need to be addressed. So that's all I have. So thank you, and back to Colby.
Thanks, Joe, and thanks again for Cooperative Extension's help throughout this. I'd like to give a little plug at tomorrow at 12:30. Cooperative Extension will be having their own breakout panel concerning Nevada's Economic Assessment Project. That project looks to provide county, state, and federal agencies and their partners with quantitative and qualitative baseline data and analyses to better understand the trends in each county's demographic, social, economic, fiscal, and environmental characteristics. And that data can be used for land use planning projects, grant writing, and overall policy assessment. That'll be a great panel. They have Jeremy Drew from Resource Concepts Incorporated, Fontaine, Executive Director of the Lincoln County Regional Development Authority, Curtis Moore, who's the Natural Resource Manager in Elko County, and Jan Morrison, Economic Development Officer at Northeastern Nevada Regional Development Authority. So that'll be a great panel, and that's tomorrow at 12:30. So thanks, Joe. Without further ado, I'd like to introduce Lincoln County Commissioner Garland Higbee, who will go ahead and introduce the panelists and get this thing kicked off.
Thank you, Colby, and welcome to the NACO convention for 2020. It's been a rough year, to say the least. Surprises never end and never cease. We're kicking this year's conference off with a panel. The change and changing landscape of public lands management. Our panelists will present on the regulatory changes that have occurred over the last few years and changes coming down the pike. And with that, with change always comes issues and problems Sometimes it's good change, sometimes it's not so much. But I'd like to start off by introducing somebody that's famous in the ranching and farming industry for the efforts that she's put into protecting us from federal overreach and federal oversight and the things that we get beat up regular over. Karen Bud Fallon was appointed to the Secretary of Interior as a Deputy Solicitor for Parks and Wildlife in November 2018. Prior to her current appointment, Karen served for 3 years in the Reagan administration, U.S. Department of Interior, Washington, D.C., as a special assistant to the Assistant Secretary for Land and Minerals Management. She later served as a law clerk to the Assistant Solicitor for Water and Power. In between her stints in Washington, D.C., she, along with her husband, Frank Fallon, were the owners of a private law firm located in Cheyenne, Wyoming. Karen has also worked as an attorney at Mountain States Legal Foundation, a public interest legal foundation in Denver, Colorado. At Department of Interior, Karen works on issues relating to the Endangered Species Act, National Wildlife Refuges, and national parks. While she was in private practice, Karen represented private property owners, ranching and farming organizations, and local governments. Karen has assisted local governments in ascertaining their rights of consistency review, cooperation and coordination in federal agency decisions, private property owners in protecting their constitutionally guaranteed property rights, other multiple uses in supporting grazing and multiple use on federal/public lands, exposing the amount of fees paid by the taxpayers under the attorney fee shifting status. Karen is an advocate, volunteer, and coach for Future Farmers of America. Karen grew up as the 5th generation rancher on her family-owned ranch in Big Piney, Wyoming. She received her undergraduate degrees and her law degrees from the University of Wyoming. Karen and Frank have 2 children, Isaac, wife Reva Fallon, and Sarah, and grandson Wesley. The next panelist will be Amanda Kester. She's the Deputy Kester. Is that how you pronounce that? Kester? All right. Welcome to our conference in Nevada, even though you're not in Nevada. Deputy Kester. Amanda Kester is an acting Deputy Assistant Secretary for the Land and Minerals Management at the Department of the Interior. She most recently served as the acting Chief of Staff and Senior Advisor at the Bureau of Land Management from June 2018 to May 2020. In 2017, she joined the Department of the Interior as an advisor in the Secretary's Office of Congressional and Legislative Affairs. Kester previously served and then Congressman Ryan K. Zinke's Energy and Natural Resources Legislative Assistant during his term in the U.S. House of Representatives. Previously, she worked for the Bipartisan Policy Center and in the office of the U.S. Senator Olympia J. Snowe. Kester was born and raised in the military family traveling between the U.S. and Europe. She graduated summa cum laude from Wilkes University in 2011. And our last panelist, Jake Tibbetts, an old friend of mine. We go way back. Very interesting individual to listen to. I've been listening to him for years. He never ceases to impress me. Jake from State Farm. All right, Jake Tibbetts' bio. Jake was born and raised in Blackfoot, Idaho on a family farm and ranch. Jake is a biologist and geospatial rangeland scientist, receiving both a BS and MS. I'll vouch for the BS there. From Idaho State University. He is the Eureka County Natural Resource Manager, where he keeps the county involved and engaged on natural resources issues and works to ensure wise use and management of the county's natural resources. Jake is the current chairman of the Nevada State Land Use Planning Advisory Council, commissioner on the Nevada State Conservation Commission, immediate past president of the Nevada Association of Conservation Districts, Nevada board member for the National Association of Conservation Districts, supervisor on the Eureka County Conservation District, member of the Nevada Pinyon Juniper Partnership Executive Committee, member of the White Pine Nye U.S. Forest Service Resource Advisory Committee, and Nevada delegate on the Council of Agricultural Research, Extension, and Teaching. Wow, that was, if I could read that too fast, I wouldn't have made it. And that is our panel for today. I'll turn it back over to Colby.
Thank you, Commissioner. At this point, I'd like to turn over the floor to Karen Bud Fallon. If you'd like to go ahead, the floor is yours.
You're muted.
All right.
There you go.
Did I make it work? Somebody nod or something. All right, I got a thumbs up. There we go.
You're good to go, Karen.
Thank you. So, good afternoon. My name is Karen Bud Fallon, and I'm Deputy Solicitor for Parks and Wildlife here at Department of Interior. I am a Wyoming ranch girl, though, and a absolute advocate for local governments. So in all of the rules and regulations, you should think of how much this administration and this department supports the idea that the best decisions that the federal government can make is in coordination and working with local governments. Because you guys understand what's important on the land more so than anybody in the federal government can ever understand. So what I want to do today is go through some of the places where local governments really have the ability to participate and to give you an idea of all of the things that you can do to support your government in dealing with the federal agencies. First, let me talk about the Endangered Species Act. I can't think of any place in Nevada that hasn't been affected by the Endangered Species Act in one form or another. In 2019, the Department of Interior did new rulemaking that tried to streamline and modernize an act that hadn't been looked at or updated in 30 years. So let me give you an example of what we did. When you look at listing determinations, a listing determination will always be based on the best scientific and commercial data available. The one thing, though, that people in rural communities understand, though, is that every endangered species listing has an economic impact. And even if the Fish and Wildlife Service can't consider that impact, that's information that the public ought to know. So part of our 2019 new rules is that we are now saying that the federal government should let the public know what the cost of these listing decisions are. Just recently, the Fish and Wildlife Service delisted the gray wolf. And if you look at that delisting, you will actually see the economic impact calculated. It was done by the Office of Management and Budget, which is a part of the federal government. And again, it's not to influence the listing, it's to let the public understand and know what listings cost so that they understand the cost of these decisions. One of the other things we did in the 2019 rules is we refined the definition of foreseeable future. Anyone that's ever looked at an endangered species listing knows that endangered species is something that is endangered throughout its range, and a threatened species is something that could be endangered in the, quote, foreseeable future. There was never a good definition, though, of foreseeable future. And given all of the issues and questions regarding changing climate and other things that happened into the future, the Fish and Wildlife Service was having a really hard time predicting if something was going to become endangered or not. So we have regulated and determined a foreseeable future, which is only as far as the data will allow, so that the agencies are not speculating about something that's 100 years into the future that we simply don't have the data to determine. If we don't have the data to determine it's threatened in the foreseeable future, it can't be listed. Another thing that we did that is really important to counties and to private landowners is our discussion about critical habitat. I think almost everyone has heard about the Weyerhaeuser decision, which was the Supreme Court decision over the dusky gopher frog. And one of the things that the Supreme Court said was that in order to be designated critical habitat, it had to be habitat first. In that case, the issue was there was a pond in Louisiana that didn't have any dusky gopher frogs in it. It had water, which is important for frogs. It also had timber growing around it, but it wasn't the right kind of timber that these frogs needed. Fish and Wildlife Service designated that as critical habitat anyway. And after working its way through the court system, the Supreme Court remanded that decision to determine if that pond was actually critical habitat or not, because it didn't necessarily have the physical and biological features necessary for the species. Now, it is true that under the statute, Fish and Wildlife can designate habitat that is not occupied by the species. And what our new rulemaking did was it said, we can still designate that unoccupied habitat as allowed by the Act. However, it has to have at least one of the physical and biological features necessary for the species so that the landowners and private property owners know that a species truly could live there, instead of what the Obama administration did, which was designating things that could be turned into habitat someday. So that was one of the big regulatory changes that we did. Another big regulatory change we made was with regard to threatened species and what's called the 4D rule. Now, for the last 30 years, the way Interior had done it is that although there is a legal and a biological difference between a threatened species and an endangered species, once a species was on the list, they were all treated exactly the same. Everything was treated as if it were endangered, even species that did not meet that definition. And so what the Fish and Wildlife Service has said is that we are going to treat endangered species and threatened species differently, and that when you do a threatened species, Fish and Wildlife Service now has to look at the threats to that species and then come up with a special rule to manage for those threats, so that you're only dealing with the issues that are specific to that individual listing, not simply a prohibition on everything that could affect the species. That is all going to be subject to public comment and review, so that the people, your counties, the citizens that are in the area where those species are can actually have an impact through public comment and review. That's going to help the Fish and Wildlife Service focus its efforts on those things that are truly endangered, and to be able to manage threatened species so they don't move up to endangered but can move off the list. Now, one of the regulations that are going to directly impact counties is our new regulation on what we call 4B2. Under Section 4B2 of the Endangered Species Act, the Secretary of Interior, at his discretion, can exclude areas of critical habitat if the benefits of exclusion outweigh the benefits of inclusion, so long as the species does not go extinct. Fish and Wildlife Service has never, ever exercised, except in minor cases, this 4B2 analysis. Department of Interior has issued draft rules. The comment period closed on those draft rules. We are getting ready to issue our final rule. And importantly for counties, what these rules say is that when we designate critical habitat, we are going to affirmatively do this balancing based on input from state governments and separately county governments. So that if we propose to designate critical habitat within your individual counties, you are going to have the ability to provide information that the Fish and Wildlife Service is now mandated to consider to exclude critical habitat from your county. Now, importantly, under 4B2, the data that can be provided is of 3 types: economic data, national security data, or other relevant impacts. Now, everyone knows what economic data is. It's going to be your ability to say that economically, if you stop use of a particular part of our county, including importantly federal lands within your county, that the economic cost is going to be too high to our county. National security, that's going to be dealt with by Department of Defense and the other Homeland Security and those guys. And the other thing our regulation did that's important to local governments is we are now defining, quote, other relevant impacts. Other relevant impacts are going to include things like employment information. It's going to include things like environmental information. For example, if designating an area as critical habitat and stopping use could lead to increases in fuel loads for catastrophic wildfire because you now don't allow livestock grazing in the area, that's one of our other relevant impacts that the Fish and Wildlife Service is required to consider if it's brought forward by a county government. Or you could look at things like invasive species. I know that pinyon juniper is a hugely invasive species and a big problem in a lot of Nevada. And if designating an area as critical habitat is going to stop management of that invasive species so that it harms the environment, that's something that your counties can bring forward as a reason to not designate critical habitat. And for the first time ever, we have now determined that federal lands are not going to automatically be designated as critical habitat. So in 30 years since the passage of the Endangered Species Act, the Fish and Wildlife Service has determined that federal lands will always be designated as critical habitat. And these new rules now are reversing that policy. And we are saying that if there are reasons to exclude a grazing allotment or a timber production area or a watershed or whatever from critical habitat because of one of the relevant impacts or because of the economic impact, the Secretary of Interior is mandated to consider that. And he shall exclude that so long as the species does not go extinct. Now, I'm going to admit that that's going to put a lot more work on local governments. In fact, we have local governments in the office before this whole stupid COVID thing, and I could actually talk to people face to face that were complaining about the amount of input local governments were getting. And the truth is if you want to take advantage of these, your county's going to have to do a lot of work. But I also think 99% of the commissioners are going to think it is worth it to have our voice heard. Now let me switch gears a little bit and talk about the National Environmental Policy Act. As you know, Council of Environmental Quality put out its new Nepa rules several months ago. I was on the writing team for those rules, and I got to tell you, I think those new Nepa rules are fabulous. They actually define effects. They eliminate the consideration of indirect and cumulative effects and determine that effect considered in a NEPA document is something that is reasonably certain to occur and reasonably foreseeable. So we're trying to limit and eliminate the speculation about what could be the worst case that could happen as part of an EIS. Now for local governments, your ability to participate has been increased. We are now saying that cooperating agencies and joint lead agencies have to be determined at the very beginning of the NEPA process, not partway through. That as a cooperating agency, you get to participate in coming up with the timeframes and the issues as part of an EIS. That local governments will now be able to actually prepare sections of an environmental impact statement with the agreement of the applicant, if you're talking about an applicant or the lead agency. So these are additional opportunities for you to be directly involved in decisions that affect your livelihood. I think one of the things I learned over the years about being a lawyer and for cowboys in Wyoming is that so much of what happens in Washington directly impacts federal and counties. And it's really funny for me to be back here in Washington and try to explain to somebody what it's like to be a county where 95% of it is owned by the federal government. And the truth is, while I have met hundreds of really fabulous people back here, it's just simply not something that people understand unless they've lived it. So that's why we really have this push to make sure that local governments were named and directly heard. And one of the other things you'll see is that you look at the new regulations and you look at what we've done is we've named local governments, county commissions, separately from governors. Now in Wyoming, I got to tell you, our governor is very responsive to rural counties in Wyoming because almost all of Wyoming is rural counties. I know that is not the case in other states. And so rather than forcing counties to try to go to the governor and then to the federal government, we have created a direct pipeline between local governments and the federal government so that your individual voices are heard. I think with that, I have just about run out of time. I'm going to listen to the rest of the presentation. I would be happy to answer any questions that you have. I want to thank you for being willing to stand up and be county commissioners. You guys really do have the most important job of all, and I strongly encourage you to really work hard to take all of the opportunities that this administration is giving you to really stand up for your people. Thank you.
Thank you again. Appreciate your time and ever taking the time to come and speak to us. The changes that you just outlined are amazing. As a county commissioner, I can see where those are really going to be beneficial if they don't wipe them all clean or something. I hope they stand.
We're going to work against that.
Okay. All right. Deputy Kester.
Great. Good afternoon, and thank you so much for giving me the opportunity to speak with you all today. I know I'm not a familiar name, but I've been working on these issues now for nearly a decade, and as was mentioned by Barlin, I spent a few years working for the Bureau of Land Management, really diving into the weeds and how we could help address so many of the issues that you all are seeing on the ground. And I think when I first came to the department back in 2017, I think the BLM that I saw then has really changed and progressed into a BLM that doesn't necessarily look how I initially saw it. And I think there's still a lot of work to be done, but I do think we've made some really amazing progress under the leadership of the president and the secretary. And one of those areas that I've been able to see firsthand is how committed we've been to addressing fire risk in the West. think it's been really amazing to see this issue elevated to the national stage in the way that it has been by the president. And, you know, under his leadership, he released an executive order 13855, which lays out for the department and its agencies different requirements for doing treatments. And we've really taken that commitment to heart. Last year, we were able to treat over 846,000 acres, and we're continuing to build on that work. I know one of the big things that I'm sure you all have a lot of interest in is the authorities that we're building upon in order to make it easier to do this important work to address fuel loads on the ground. And so I have a couple updates for you all. I know in April of this year, Secretary Bernhardt signed the record of decision for the Great Basin Fuel Breaks EIS, which was a significant undertaking and really exciting, not only in terms of meeting the goals of the executive order and then Secretary Order 3372, but the last administration had looked at doing a Great Basin Fuel Breaks type NEPA, and they opted not to. They thought it would be too difficult, and as soon as we came in 2017, we said, this is something we need to get done. We need to be, as in we, the federal government, need to be proactive and help states and counties fight fire. And so much of the activity was happening on our lands. So we need to step up and be good neighbors. And so seeing that record decision signed in April was very, like I said, very exciting. It was huge to be able to get that done. And since then, field offices have been working off of that NEPA to do individual projects. And then around the same time, we announced the availability of the Great Basin Fuels Reduction Draft EIS, which was out for public comment until June. And that analyzed within the same area as the Great Basin Fuels Fuel Break NEPA. So it assessed in the preferred alternative nearly 38 million acres of treatments to reduce fuel loads and to restore rangeland productivity through manual, chemical, mechanical treatments, including prescribed burns, seeding, and targeted grazing. And that's a big thing that we've, at least since I've been at the department, seeing a big uptick, including in Nevada, on the use of targeted grazing as a tool to reduce fire. And so to include that not only in this NEPA, but I know that under the leadership of the Nevada State Office, they've been undertaking some efforts to continue to use targeted grazing as a tool to reduce fire. So that effort in relation to Great Basin Fuels Reduction, we're working on getting that finalized EIS out and hoping to mobilize to get that done quickly so that that can be a tool for field offices to use on the ground in coordination with you all. And I think with the Fuel Breaks project, we've had some good coordination there. These two EISs really do marry up and support each other. Our hope is that this will really allow us to make some meaningful progress on the ground, building on some of the efforts that we've been able to undertake to date. In addition to those, we've been working on categorical exclusions to create additional efficiencies. One of those is the Pinyon Juniper Cadex, which we put out for public comment in late spring. And so we're working as quickly as we can to finalize that Cadex. The draft that was out this spring, and I'm sure many of you commented on that, would allow for up to 10,000 acres of treatment. We think this is a really smart categorical exclusion. We think it'll create a lot of efficiency, and our hope is that it could play into a lot of the NEPA that we finalized with the Great Basin and help, move those efforts along expeditiously. So in addition to that, one thing I wanted to note, I'm sure many of you are familiar with Casey Hammond, but he was out in Nevada earlier this year and went to check out some fuel breaks outside of Reno. And they were able to show him how those fuel breaks actually helped mitigate fire, completely change the fire behavior. And we want to continue to build on those efforts. We think it's, especially in the Great Basin and all the fire activity in Nevada, this is a good start. But like I've noted, I think that there's a lot to continue to build on here to meaningfully address fire risk across the West. Another thing I know you all have interest in is the BLM's efforts to update its grazing regulations. And as you well know, our current regulations are well over 25 years old. And in that time, the industry itself has changed and evolved, and the BLM's approach to managing its land has evolved in that time as well. So I know conditions on the ground has certainly evolved over the past 25, 30 years. You have the increased activity for wildfire, increased presence of invasive species, and other factors that are at play. And within that time too, the legal and the regulatory framework has changed quite significantly based on, decisions by judges and changes in laws. So we believe that our grazing regulations need to be updated and modified to align with current conditions. So as some of you well know, last winter, we began our effort. We released our notice of intent to modernize and streamline our grazing regulations. And we were able to host some scoping meetings in the early spring, including in Elko. So thank you for those who were able to attend and offer your scoping comments. We received in total over 8,300 scoping comments. So between that and the incredible number of attendees that we had at each of our meetings, it really affirmed for us that this was an incredibly important effort. And those comments have continued to be immensely helpful as as I'm sure you all saw, we released our scoping report in June, which catalogs and lays out those comments very clearly, and those have all been used to inform work on the EIS. And late this summer, we began to enter into cooperating agency agreements with counties across the West, including several counties in Nevada, which has been a very exciting effort. We have over 30 cooperating agencies, and we've received incredibly helpful feedback on the draft EIS. So we're taking all of that feedback in addition to the scoping comments, and our hope and our plan is to use that to strengthen and improve our administration of grazing permits across the West. In addition to that, like I've noted, we're continuing to work on that effort, and upon the draft EIS being released, in addition to the draft rule, there would be a 60-day comment period. And then we would work with the public to review those comments on both of those efforts and use that to inform additional changes to the grazing regulations. So with that, one other thing I'd just like to note, I think the topic of this panel is quite fitting when we talk about kind of what has changed, what we're changing, and looking forward. And I think the relocation of the BLM's headquarters to Grand Junction really will change the landscape of how the BLM specifically engages with entities like you all. The whole point of the move, there were many, many good reasons to do it. But at the end of the day, we needed to move the decision-making closer to the lands that the Bureau manages and to the communities that are impacted by how the Bureau manages. And the intent is to continue to ensure that that's a success, and that when you all have issues, you can go to the headquarters office and educate the people there who staff that office and share with them how their policy decisions, how their regulatory decisions are impacting your day-to-day lives. So with that, that's just a quick overview of what's going on within the Bureau, but I'm happy to answer any questions you may have. Thank you.
Okay, thank you, Director Kester. We'll now move to Jake Tibbetts.
All right, thanks, Farland. So it's Jake from State Farm, don't forget.
Love it.
So if you look, I decided to put this background up behind me rather than my disorganized office, so I'm not as organized as Karen's office there. But Varlin, you look like maybe you have a little disorganization going on behind you. So.
Just a little bit, just a little bit.
But I thought this was a good background because this is, in my opinion, a good example of land management for many of us and public lands management. So you can see, you know, agriculture, you can see rangelands. If you know where to look, you can pick out a couple mines. There's checkerboard ownership out here, sage grouse habitat. You can see pinyon juniper expansion and energy transmission. But if you really notice, you'll see a haze of smoke in the air. So when this photo was taken, there were wildfires going on throughout the West. So, and that is, again, one of the top issues that we're facing. From my perspective, I see the changes that were discussed by both Karen and Amanda as extremely positive. I echo what Varlin said, where they are very good changes. I want to thank them for their leadership in developing and implementing these common sense changes, this good public lands policy, and bolstering really the principle of multiple use management. I was really glad to hear Karen speak towards the efforts to try to keep these changes in place moving forward, regardless of whatever the administration is. So my county, Eureka County, we've been actively engaged in many of these things that have been discussed. We've, you know, whether they're through formal commenting, we've been a cooperating agency and are a cooperating agency on some of these Nepa processes, the programmatic EISs, the grazing regulations, a lot of these things. So we've, with many of you as well that are attending today, we have had a really active role. And I'll echo what Karen said, that it takes a lot of work and effort by the counties if you're going to engage in these processes. And then to stay involved once you have that good policy or the NEPA's in place or the right regulations or rules are in place, you have to really focus at that point to get good implementation on the ground. So I was reflecting on the theme of today's panel, and it's the changed and changing landscape of public lands management. And as I was reflecting on this theme, it was really tempered with knowledge of the recent election, the results from that, and what is looking to be a new administration here in the new year. So that creates a big question in my mind on what is to continue to be the ever-changing landscape of public lands management. So I was thinking back to when I first started working for Eureka County over 12 years ago. And when I started this job, the first thing I did is I started to pore over the files and the actions that were taken by my predecessors, and also our County Natural Resource Advisory Commission called NRAC. And so I read the NRAC minutes from the early 1990s, and I could have cut and pasted those issues that they are working on into the minutes from the meetings 12 years later, or 12 years ago. And I could honestly take those things from the early 1990s and cut and paste those into our minutes on issues that we're working on today. So I had to ask myself the question, you know, really what has changed in public lands management over this whole time, not just this last 4 years. And I came to the conclusion that it really is a positive thing that we continue to work on these issues. So from my perspective, having these same issues to work on, it means that we haven't lost our position and our voice. We haven't lost on these issues. They're still around to continue to work on. So what's really amazing to us, and we're very happy to see, is these programmatic NEPA documents, the fuels breaks, the roadside fuels breaks, as well as the rangeland restoration and fuels management that Amanda discussed. We're happy to see some categorical exclusion authority come back into the mix. And that is so important to us, where we can quit talking about the issues. We can get over the NEPA hurdles that have been a common excuse for many of us for many years, and we can actually start getting real good work done on the ground. So we've also seen a lot of progress being made in the arena of wild horse and burro management, with some of the direction the BLM has taken, as well as some of the additional appropriations Congress has granted for that. Again, we're really happy to see the grazing regulations move forward. We're just hoping we can push those across the finish line and give them some kind of protection as they move forward. But one thing is sure, the pendulum will continue to sway and swing back and forth across various administrations, and we'll continue to see these issues in different contexts and in different shades as we move forward. So being involved in what I see as two very distinct administrations over the past 12 years that have had diverse and different goals and policies and approaches. I've experienced other regulations and Nepa efforts that were significant in some local BLM districts or field offices, but they really didn't translate to others. So in my opinion, the key to any good public land management rule or policy or management tool, it nearly always boils down to the translation and the implementation at the local level. So some things intended for change from Washington, D.C., and good changes don't always translate to good changes at the local level. And local relationships with our local, BLM offices and Forest Service offices, those really do matter. These relationships, they'll stand against the sways and swings of these administration changes, and they'll temper some of the angst when these policies or rules are not as favorable as we would like. So with that being said, we have experienced that some of these Department of Interior or these BLM streamlining measures can sometimes work against our mantra of keep it local, as Karen mentioned, the locally led management. So meaning, the local BLM actively working for that principled coordination with the counties and striving to find that consistency with local plans and policies and controls to the maximum extent possible. So we're very happy to see those changes, those overall changes in the NEPA regulations to push us that way a little more. But this principled coordination, it really takes time. It takes a lot of commitment. And when timelines are shortened or streamlined, we have actually experienced some BLM offices sacrificing this local government coordination as kind of the collateral damage, with the excuse of they have a shortened time frame to get something done, and this coordination sometimes falls by the wayside. So the time for this meaningful coordination with local governments is well before any planning or any rule development or any NEPA process. It's early and ongoing, and I know Karen will agree with me on that. But sometimes that translation has just been lost for us at the local level. So comment periods are often something, we receive the same document to review at the time of the general public. There's been no outreach with the counties often ahead of time. And we argue that a public comment period is not the same as coordination with a county. So coordination, it implies active participation above that afforded just the general public. Because local government entities, county commissioners, guys are elected by the people. You're accountable to the people. You're the only entity in my mind that's able to incorporate and legitimize the compromises necessary at that local level for good land management. And it's the regular principled coordination that's really going to put conflicts behind us. It's not saying we're always going to be consistent with our federal agency partners, but it at least provides an avenue to try to work that out. And in the end, I really believe that including and properly defining coordination at the local level will work now to build that foundation and make sure that we can bring back these management decisions where they should be made at the necessary scale, and that's the local scale. So I've advocated for quite a few years that local government coordination, while it is, we can point to various regulations, both NEPA and FLPMA, talking about coordination, that sometimes, again, that doesn't translate back to the local level. And I think Washington, D.C., the Washington Office of BLM and the Department of Interior need to really provide that guidance back down to each BLM district and each field office so that they can empower them, they can support these offices to enter into maybe even formal coordination protocols, some kind of memorandum of agreement or memorandum of understanding. And I'm not talking about cooperating agency MOUs, just a more general, how do we work together on issues of common concern, that really lays out the process, and it gets people at the table talking about issues before they become a big conflict. And I think by getting these things in place, it would help the counties also understand their role and how the commitment that they need to have to the process moving forward. And then these formal agreements could stand the test of different administrations, different county commissioners, when new county commissioners are elected, and it could be something that could really last and have a good lasting power moving forward. So again, all these positive changes we're talking about, they only mean something when they're translated down to the local level. And that's where we are seeing a lot of huge inconsistencies and various shades of successful implementation and coordination. But it also takes counties understanding your role and the mandates of the land management agencies, and then really being bird dogs and continuing to ensure you have a spot at the table, continuing to recognize and remind our local BLM offices about you know, their mandate to have us there to help be making these important decisions. So with that, Varlin and Kobe, we're all in for now and ready to take any questions.
There we go. Wouldn't turn back on it. I'd like to take a minute and thank Kobe Prout, our administrator for the Public Lands and Natural Resources here in Nevada for our Nevada NACO subcommittee. He spent a lot of time and effort putting this thing together, and he spends a lot of time and effort preparing for our board meetings that we have. And I just like to acknowledge his efforts in doing this. And now I'll turn the time over to him for questions and answers.
Thanks, Commissioner. I appreciate that. And I'd like to thank Amanda Evans, our office manager, for organizing this. It's much more difficult, I'm sure, virtually than it is in person. But hopefully soon we'll be back to in person again. Well, while we wait for a few Q&As to come in from the audience, if there's questions between the panelists, or Varlin, if you have any questions for the panelists, I'll defer to that first. I do have a couple that we can ask while we wait for questions to come in, but if you have questions for each other, that we can do that first. No? Okay. Well, I have a question I could ask for Karen. You talked about the 4D rule and how it's the new version will be, it won't follow the blanket area where a threatened species would get the same treatment as an endangered species. You talked a little bit, has there been any new petitions that have come down under the threatened or any species that have been determined to be threatened since that new rule? Or if you could talk what that would look like. Would that be kind of like a conservation plan going forward, or exactly how would they treat that since they're not treating them as endangered species anymore?
Sure. So one example I can think of is that we recently listed, it was some bug in Texas. I don't remember the name of the bug, but it was some bug in Texas. And the issue with the bug was basically it lives in dead stuff, and that's what it uses for its host. And so, but that was the only issue with this silly bug. And so as we wrote our 4D rule, we did not have to regulate other private property uses such as livestock grazing or anything like that used the surface of the land. We only had to look at issues with regard to pipelines. And so our 4D rule only dealt with pipelines, and we put together special conditions that if you wanted to put in a pipeline across the habitat for this stupid bug whose name I can't remember, you had to just follow those certain conditions. And every other use of that habitat was left alone. Whereas if it would have been endangered, then everything would have been regulated and you had to get special use to, continue grazing or continue plowing or continue whatever the surface use of the land was.
And is there a notice and comment period on that?
Yes.
Okay.
Yes, so when we list something as threatened, it's going to include a draft 4D rule that says these are the threats to the species and these how directly we're going to manage the threats, and everything else can continue as business as usual, so that the public then can comment on the specific threats and then the specific proposals to manage the threats.
Thank you for that. So we have a question here from Jamie Drew from RCI. Given some of the shortened Nepa timeframes that Jake mentioned, what are some of the ways that counties can proactively prepare for participating in Nepa or other planning processes? Jake, I think, referred to that. Jake.
Sure, the answer to that is that's why when you look at the regulations, we are involving either cooperating agencies. NEPA is what allows cooperating agencies. So we're involving those much earlier in the process to try to give you that heads up. Because I understand what you're talking about when you're saying there's less time. The problem is you had NEPA documents that were taking 10 years to be able to get a final decision out. And so if you had an applicant that was applying for a big project like a mine, I mean, they can't hold funding for 10 years to get a NEPA document out. So that, I mean, so that's what we tried to balance, the time it takes to get a decision, which shouldn't be completely ridiculous, with getting good information. And that's why we moved up local governments to be involved earlier in the process. The coordination Dake was talking about is something that occurs under Flipman. And I think your thoughts about doing something that would more affirmatively state that to the BLM, I'm not technologically smart enough to be able to send an email to Amanda and do this at the same time. But since I see Amanda, I'm going to tell you, we ought to talk about maybe how we could put together director's guidance on doing that, because I think that's a great idea.
I agree with that. And Jake, I would be curious, and we can talk offline, but I'd love to hear some of the examples that you're referring to broadly about issues that you've had and what field offices. I think it'd be good to get to the root of that.
Okay, thank you for that. Another question we have from Dave Mendiola, the manager in Humboldt County. This is for you, Karen. You mentioned that redefining quote, foreseeable future and mentioned that speculation of data would not be allowed. How do you avoid that when computer models are used to attempt what is a predictable outcome?
I've got a couple of answers to that. One of them is that we now have the policy that both the computer models and the input are going to be open for public comment, so that the public can say either you've got the wrong inputs or the model is wrong, or whatever the public's going to say. And so that should help that process. The place where we were really finding this foreseeable future problem is when you're talking about climate change. And if you look at the models for the climate change, they all go parallel for a little while and then they get vastly different. And we're saying that if you're going to use modeling, you can only look at it so far as the model is reliable. And then when it starts getting variables that either you can't measure or we don't understand, you can't consider it any longer.
Okay, thank you for that. We do have a question, which will be over the phone from Commissioner Dahl and Elko. Is he on yet?
Yes, he's allowed to speak. Damar, you may unmute your mic to ask the question.
Hi, Damar.
You may have to unmute him.
And I believe he just unmuted his mic.
There
So
you go.
Damar, please take it away.
Thanks, Joe. He muted him.
Commissioner Dahl, you're free to speak. So we may be having another difficulty there. We'll keep his question pending. We have another question. We have another question what will have to change to get good fed agency personnel to stay in one office long enough to get to know the area and be a positive influence? I will let either Amanda or Karen answer this question.
Oh, that's an Amanda question.
I'm certainly happy to take a stab at that. And I think that's a very good question. And that's an issue that I've seen throughout my time here. We've been working, especially in places like Nevada, to attract talent, provide incentives in order for talented people to stay. And I think it's something that, you know, we definitely need to continue to work to build on that. I will say that, you know, in relocating the BLM headquarters, we did see a lot of good talent from people across the West who said, I never wanted to go to DC, but now I can be engaged in headquarters issues out West. And so I think we need to kind of continue to take the lessons learned from that and employ them in our field offices, our district offices, and state offices so that we can have talent continue to be present to serve, you know, each of our states.
Thank you for that answer. Do we have Commissioner Dahl on yet, Joe?
Can you hear me?
Excellent.
Yes, we can.
You can? Okay. Did he say good? Okay, my question is for Karen, and it concerns the secretarial order that affects what Rob
Hey,
mentioned.
Damar,
Yes.
Closer to your phone.
you got to get closer to the phone. I can't hear you.
Where's the phone?
It's the computers.
Okay, well, where's there go? Okay, can you hear me now?
Yes, sir.
Okay, all right. My question, Karen, concerns the secretarial order that apparently just came out the other day that addresses what Rob Bishop refers to as the Not So Great American Land Act, which requires that before any private property can be acquired by the federal government, that they have to have the okay from the governor and the county that the property is in.
Yes.
And which is great news for us. I was just wondering if the administration changes, what's the chances of that secretarial order remaining?
Well, the hard part with secretarial orders is that they can change with secretaries. What we're doing in this case to try to shore that up for the next administration is that the LWCF funding is also being run by the National Park Service. And so we are also changing now their manuals, their handbooks, and other documents to try to get that information in those as well, to make it harder for that to automatically change. I mean, we are very aware of the change in administration, and we are working really hard to try to make sure that what we have done stays in place for the long term.
Good for you. Thank you.
Thank you, Commissioner Dahl, for that question. Again, if you have any questions, you'll see there's a small Q&A chat option in the bottom of your video window through Whova, so please type in any questions you have. I had one question while we wait for another to come in for Amanda. I noticed we noticed that a lot of the new management tools that the BLM was taking with the programmatic EIS for rangeland restoration, categorical exclusion, et cetera, they all seem to kind of coming out, in pretty quick sequence. Was that a strategic decision, or was that something that was just, there was kind of a backlog of things BLM thought they needed to get done and they saw an opportunity to do it?
Sorry, you broke up a little bit. So you were asking if we intentionally tried to sequence the EISs?
Yeah, basically whether there's a larger strategy of kind of having things work kind of in sync, or whether that was just kind of in virtue of the fact there was a lot to do?
So we definitely wanted these to be in sync. I think for us, we realized field breaks are a scientifically proven helpful tool. And we wanted to get that effort started very quickly so that way our field offices could work with locals to get that built out. At the same time though, there are other treatments that can be very easily done to help kind of work in tandem with field breaks. So things like prescribed fire, targeted grazing. And so the idea was that we wanted them to work together. The sequencing ultimately was, like I said, field breaks was finalized first. We're working to get the fuels reduction side done as well. But we think that in order to effectively fight fire and reduce fire risk out west, we need every tool available to us. And that's why actually doing this NEPA and getting it across the finish line is I think it's a pretty big deal. Now, I think we could do more, but this is exciting stuff that I think it really speaks to the president and the secretary's commitment to be out there and address these issues in a meaningful way, which is why we've been pushing for the last few years to kind of get our fuel treatment numbers up. And we've reached decade level successes because of prioritizing and being aggressive on this, but we need more tools. And so that's why those two efforts together are really important. And, working on the PJ CADEX, that was called out in Secretarial Order 3356, but that's one too, that tool can be used in implementing that NEPA. So altogether, I think we just wanted to go out there and really make a difference when it comes to reducing fire risk.
Thank you for that. Well, I don't see any further questions coming out of our Q&A, so unless...
I have a question.
All right, very good.
I guess either one we could feel this. I know in 16 and 17, there was some movement to shrink the size of the monuments to meet the definition of a monument. Has there been any movement on that? Because we, here in Nevada, we ended up with 2 that we didn't really ask for or want.
So just to clarify, are you referring to there was like a public comment process and a report that was submitted to the president? Do you mean about the president taking those actions?
Yes.
So I think all of that is in the hands of the White House. I know that for the Utah monuments, those efforts were completed and that ended up in litigation. So I think we're still waiting for a judge to make a decision about presidential authority. I can check back into that if you'd like.
Sure. See, that goes back to the same thing that we talked about earlier in this session. When they created the 2 monuments in Southern Nevada, there was absolutely zero coordination with Lincoln County. It just was, it was just there. That here you go. I mean, they didn't ask, they didn't even, no heads up. And I think it was done the same way in Utah when they created those monuments. And it severely impacts our ability to grow. Some of there's oil and gas leases that are on those monuments, and there's our Lincoln County Water District has water filings in those monuments that we can't pipe or sell the water off those leases.
We have a question from Commissioner French out of Humboldt County. He's also the NACO Board of Directors President. What are some of the short-term plans for the Wild Horse and Burro program, referring specifically to funding and staffing of that program?
It's a great question. So as you well know, Congress gave us an additional $21 million for the program, and we went to work to build out a pilot program that we identified areas, including some in Nevada, where we felt like we could get HMAs down to AML using a couple of different tools. So fertility control is a really important component of this issue for us, that we feel like, doing gathers and moving them off the range, yeah, that's certainly one part of it, but we need to look at some longer term options. And so consistent with our report to Congress that we sent in May of this year, we've been using that 21 million to really implement that effort. And so we've made some really good strides on that. And I think it was interesting, the Senate, when it released its Interior Appropriations budget and its report, it did acknowledge that they felt like we had worked on a good plan, and they wanted to fund us and see how it continues to move forward. And so we're still working to implement, as I mentioned, our pilot that we created with that additional 21 million. We were able to gather quite a number of horses this year, make some really strategic investments in treatments and fertility controls beyond PZP. And then on the staffing part, so I know we've been trying to prioritize and fill those positions. We have some great people that are working to support the program in the immediate, and we're going to continue to work to fill some of those high-level positions as quickly as we can. But I will say too, you know, one thing that we're kind of amazed by was the adoption incentive program. We kind of went out on a stretch and thought, all right, if we're going to give people $1,000 to adopt horses, let's see how it works. And even during the pandemic, we were able to get a lot of horses adopted. So we want to continue to build on the success that we've seen with that program too.
Great, thank you for that. Another question, we have it from Jeremy Drew again. In regards to the Nevada Economic Assessment Project, which is creating the kind of the baseline socioeconomic data for counties across the state, what socioeconomic data is the most important to collect now in order to effectively participate in future federal planning processes? I could leave that, maybe Karen, if you have a perspective on that under NEPA, or anyone who wants to jump in would be fine.
Well, I think some of it's going to depend on the decision you're looking at. I would say, though, that now that we are including the ability to eliminate federal lands from critical habitat designations, that I would definitely make sure you had things like circulating dollars from federal land leases, knowing that federal lands make up such a significant portion of Nevada. I would look at things like circulating dollars. I would look at related jobs to federal land leases as well as private land. This president really believed in employment numbers, so I would really look at employment numbers and what a proposed decision is going to do to increase or decrease employment, because that was something the president had us put into all of these regulations and actually talk about, like in the NEPA regulations that mentions employment, in the new 4B2 regulations it's going to mention employment. So I mean, I haven't seen your document, your economic document, so I don't know exactly what's in it, but those are some of the things that I would really look at. And then I would suggest, I don't know what your document looks like, but if you can take whatever information and tailor it down to your specific county, I think that will help. Right? One of the things that we're telling local governments to do is you can't just submit generalized economic data and then say, we just don't like your decision. The more that you can relate that to your specific county, the better use it's going to be for you.
That's excellent. I'm sure, Joe, you were listening.
Yes, can I just speak briefly? Yeah, the Nevada Economic Assessment Project, which you can learn more tomorrow at 12:30. They are county by county specific. So it's a baseline of social, demographic, fiscal, land use data specific to each county within Nevada. And there will also be IO models, there we go. That's the word I was looking for. IO models that based on in-plan that will be adjusted per county as well.
You know, the other thing that I would be remiss if I didn't also mention is that if you look at the Nepa rules and the 4B2 rules, we also talk about custom and culture of these local counties. And it is different if you live in a county where they make their living cutting trees off the forest than if they make them as a bunch of cowboys on the desert. I mean, they're rural counties, they rely on federal or public lands. I understand that, but the people are different and what they do is different. And so I don't know if your plan includes that kind of information or if that's something the counties need to develop individually, but we also are including the social and cultural data as a metric that the agencies now have to consider as they're making these decisions. And that really is going to be county by county. A mining county is different than a livestock county. And we're trying to account for those differences, and the counties are going to be the ones that point that
out. Yes, absolutely. And we will have, as well as the baseline data, we'll also have industry specific reports specific to mining, agriculture, and some other items as well, especially focused on public land use, because we know how important it is to our counties here. But I know that we've gotten a few more questions, Colby. So more information, 12:30 tomorrow. Please join us.
Thanks, Joe. And thanks for the answer, Karen. This question is from Commissioner Lister of Lincoln County. Many of our counties and other local entities have facilities on land under RMPP grants. Is there a path to unrestricted patent or title to those lands?
So there is, and what I would say is it does depend on the patent that you have. And I know some patents in Nevada, especially going back to the 60s, have some language that offer different options. But what I would say is if you're interested in moving forward on an RMPP and securing that interest in land, it's good to start off with your field office. But if it's helpful, I'm also happy to discuss specific instances outside of this panel.
Okay, thank you for that. This is another question from Commissioner Urquiaga of Churchill County. When is the BLM, or he'd like an update on the Carson RMP and the Southern Nevada District started and stopped. Many RMPs in Nevada are 25 or more years old.
So I'm happy to look into Carson City, but typically the way that the Bureau does its land use planning is that it looks at its older plans and works on updating them. I'm curious though about why there hasn't been so many planning efforts in Nevada, so I'm happy to take a look into that.
Thank you. Well, at this time, I don't see any further questions unless...
Colby, I actually have one, if you'll indulge me.
Yeah, of course.
While I have Karen and Amanda as a captive audience. One issue that's kind of starting to really bubble and causing quite a bit of conflict and controversy is the BLM Public Water Reserve 107. Mm-hmm. So we're going through an active adjudication in this valley, you can see right behind me. And the BLM under that, you know, it's a McCarran Act adjudication. So the BLM filed for 66 claims of public water reserve, and it's creating a lot of conflict in some of these areas where there's, you know, certain other leases on the ground and non-metalliferous mining activity and grazing impacts. And anyways, it just seems that it's going to continue to be an issue that bubbles up. You know, those are tied back to a presidential executive order of 1926. And it seems like in today's day and age with, you know, the whole gamut of environmental laws and FLPMA and Nepa and everything else, and the ranges are settled. Most of these water rights, you know, were vested even before 1926, and it just seems like an unnecessary conflict that could be easily overcome through some other kind of presidential action, or, you know, I'm not sure. But the Department of Justice attorneys are being very aggressive on this and creating, it just seems like it's a conflict that we could avoid with in today's day and age. We're not in the 1920s anymore. So I don't know if you'd seen that happen in other states, or I see this issue going all the way to the Nevada Supreme Court, you know, and it just seems like something that we shouldn't have to spend all our time and get people on opposite sides on.
So I've been aware of the issue at a high level as it relates to certain projects in Nevada, but I don't think I realized the component about DOJ and the fact that BLM has filed claims. So I'd like to dive into this a bit more, if that's okay, and we can talk about it after if that works.
Okay, great, thank you.
Hey, thanks for considering that. Well, I'd like to thank all the attendees for asking their questions. And then that pretty much concludes the question and answer session. I guess I'll turn it over to Commissioner Higbee if you wanted to say a few last things. I'd like to thank all our panelists for showing up today, our sponsor, PoolPact, and Joe for your technical support. It was greatly appreciated. Commissioner Higbee?
Yes, I'd just like to give a shout out to our panel. Appreciate their time and effort. And it's sometimes on a panel like that, you get questions thrown at you that are curveballs and a lot of things that you're not really prepared to answer. And so you've done an amazing job, and just thank you. And also a thank you to Mike, I can't have Rebelati. Is that how you pronounce that? I'm terrible with names. I apologize. And Joel and Dickie and our staff, Colby and Amanda, that have put this thing together. I greatly appreciate them and all their efforts, and hope you enjoy the rest of the conference. Thank you.
All right, thanks everyone.